Okay, we are back on the record now on KCR 22211624, State of Idaho versus Noreen Vallow Daybell. We've got, four motions scheduled, all related to the death penalty in this case. They've been filed by counsel. The court has reviewed the pleadings, and the state's filed a response to the first motion. We'll call them up in the order I previously discussed. So if you're ready to proceed, Mr. Archibald, then we'll start with the motion to declare the death penalty unconstitutional, and that was filed on November 23rd. If you'd like to present your argument at this time, you may.
Yes, thank you, Your Honor. This motion to declare the death penalty unconstitutional is a standard motion that's filed by death penalty lawyers nationwide. I won't take authorship credit for it, but it is something that we death penalty lawyers continually fight. We ask trial courts to declare the death penalty unconstitutional. We understand trial courts usually deny our motion and leave it for the appellate court. And so I won't rehash everything that's in this 60-page motion, but it does attack the constitutionality of the death penalty as being violative of the Constitution of the United States under the cruel and unusual punishment. At one time, the United States Supreme Court agreed, and the death penalty was put on hold nationwide. And then slowly, since the 1970s, the states have reinstituted the death penalty. So this is an issue that takes into account the equal protection of clients, the Sixth Amendment, the Eighth Amendment, the 14th Amendment to the Constitution. As indicated, there's been studies on the death penalty nationwide. The Capital Jury Project finds that juries and decisions about the death penalty are routinely flawed. I don't think anyone in the courtroom would not have seen some death penalty overturned because of some flaw in the system or some flaw in the decision making. So the issues in the death penalty deal with humans, the jury, making decisions, and we all know humans are subject to error, and they do sometimes make decisions in death penalty cases prior to even hearing the mitigation. There's bias in the jury selection. We'll talk about that. The instructions to the jury are complicated. We've asked this court already to remand the indictment to the grand jury because of the complicated nature of the conspiracy charge. And that, of course, we respect the court denying that, but I'm positive that our jury will have questions about it. Sometimes our jurors believe that the death penalty is required. If the state is seeking it, then some jurors think the death penalty is required. And so some jurors don't think that there's an alternative, that it's either that, and so that's what the Capital Jury Project has pointed out. And in this 60-page motion, that's just a history of that process. So, as a death penalty lawyer who has done many of these cases, that's why we try to settle. We try to settle before we get to the point. There's some death penalty lawyers that say if you're actually in trial, you've lost. And why? Because the jury is prone to convict. The jury is prone to give a death sentence if they've been evaluated and approved to be on a jury who's given basically a license to kill. So that's what this death penalty motion is about, Your Honor.
All right. Thank you, Mr. Archibald. What's the state's response?
Thank you, Your Honor. Lindsay Blake for the state. When we look at the motion that was filed, and I respect and understand what Mr. Archibald's saying, that this is a fairly standard motion that's filed in death penalty cases. The state's observation or position would be that this simply isn't ripe until death is actually imposed. And I think in our response, we had cited to case law reflecting that, specifically Texas v. U.S. 523 U.S. 296. A claim is not ripe for adjudication if it rests upon contingent future events that may not occur as anticipated or indeed may not occur at all. And then looking to Sheffer v. Reno, 55 F3D 1517. Eighth Amendment claims of cruel and unusual punishment are not ripe when raised prior to the actual or immediately pending imposition of the challenged form of punishment. So first and foremost, the state would simply request that this court deny the motion as not ripe at this time. Notwithstanding that, and since we have heard argument regarding the content of the motion itself and the arguments, essentially the motion boils down to two challenges to the Idaho process of the use of the death penalty. Number one being the bifurcated proceedings, and number two, Idaho's statutory instructional procedures to inform jurors. When we look at that, Idaho, there has been, defense talked about the death penalty going away for a while and coming back. What they address in their motion is a line of cases that have kind of gone in and modified the capital sentencing procedure, and it's often referred to as the Furman and Gregg line of cases. Idaho meets the requirements that are set out in that line of cases because we do have the bifurcating procedure, and it is meant to limit the application of the death penalty to the most severe cases. Idaho Code 19-2515 lays out what could qualify for capital punishment and limits it to cases where not only is the defendant found guilty of first-degree murder, but the jury also finds one of the statutory aggravating circumstances beyond a reasonable doubt. That is required before we even get to the mitigation. And to further protect things, Idaho's procedure is split up even clearer than that. When we're dealing with a death penalty case, the first and foremost question is that of guilt. And on the verdict form, it only deals with whether they're guilty or not guilty of the charge. Then if they are found guilty of first-degree murder, we would move on to the aggravating portion of it, or the penalty phase, where the jury would have to find an aggravator beyond a reasonable doubt. And then they would have to weigh that against any mitigation evidence presented prior to the imposition of whatever sentence the jury were to decide is appropriate, whether that be life or death. Idaho has clearly complied with the requirements that it be set out that way. As case law has evolved, Idaho has continued to comply with the Ring ruling. Idaho did comply by changing their statute to require the jury to find the aggravating and weigh the mitigating instead of the court. And you can find a citation to the Ring in that finding in State v. Abdullah 150, Idaho 386, 2015. The defendant has not identified any single aspect of the bifurcated proceeding that fails to meet the requirements as outlined. And contrary to the unspecified allegations of noncompliance, Idaho has tailored the sentencing procedures to avoid arbitrary and capricious imposition of the death penalty. Again, Idaho has limited the imposition to cases with first-degree murder and where an aggravator is found beyond reasonable doubt for an individual to even be eligible to receive the death penalty. The state in this case gave notice of the statutory aggravators that they may rely on, and those statutory aggravators have all been upheld as well. The one regarding remuneration is fairly straightforward. There shouldn't be confusion there. State v. Hall, 163 Idaho 744-1991 has dealt with some of the other aggravators and found them not constitutionally vague. And specifically with the utter disregard aggravator, even the U.S. Supreme Court has approved that in Array v. Creech, 507 U.S. 463. And furthermore, propensity was reviewed in Hall as well. It has been upheld time and again. There is a limiting construction that was provided by State v. Creech, and it's been upheld repeatedly so long as we have those limiting constructions provided as well. In addition, the procedure for the sentencing is clearly outlined in the Idaho statute. If we turn to 19.2515, 7A through C, it clearly outlines the process for the imposition and what would be what the jury's role is with that and what the judge has to inform the jury when dealing with a capital case. That's clearly outlined to avoid the confusion or misunderstanding that was referenced by Mr. Archibald. The defense did cite to some papers that dealt with conversations with jurors in death penalty cases. And what seemed to come out is that there had been some confusion or there was a lack of jury instructions in a lot of those cases. But what is most paramount to the state is none of those papers deal with jurors in Idaho or specifically Idaho jurors being asked about the imposition of the death penalty. And I think the Idaho construction of the statutes, the instructions that must be given to the jurors, clearly outline and indicate to the jurors what must be done. It was also mentioned that jurors often indicated that they had questions or were left with confusion. I don't think it's uncommon for jurors to potentially have questions. That's why they have the ability to at times ask the judge questions, and those jury instructions provide them the guidance. And so I think it is paramount that appropriate jury instructions be provided. We do have Idaho model jury instructions that deal with that as well, specifically 1718 and 1719. The state is unaware of any challenge to the instructions that have created concern for the courts in the past on death penalty cases, again, dealing specifically with Idaho. The bulk of the argument presented by defense dealt with death penalty as a whole across the nation and not specifically to Idaho or specifically indicating where there is any flaw or lack of compliance by the provisions set out in the Idaho statutes. So again, we just reiterate that the defense, we believe their motion is not ripe for consideration at this point in time, but if the court does consider it or does not deny it based on the lack of ripeness, we believe it should be denied because they failed to identify one single aspect of Idaho's system that fails to comply with constitutional mandates of the U.S. or Idaho constitutions or Supreme Court cases.
All right, thank you, Ms. Blake, for the argument. Mr. Archibald, any rebuttal argument?
No, Your Honor.
Okay. Counsel, it's a technical motion, as you've stated. Mr. Archibald, a lengthy motion that cites a voluminous amount of materials and authority, and so for those reasons, the court will take the issue under advisement and issue a written determination on that motion. The next motion we will call up then is the motion to declare Idaho's capital punishment scheme unconstitutional. That is filed on January 2nd. And on that particular motion, the state filed an objection and a response to the motion on January 12th. So the matter is scheduled for hearing today. Mr. Archibald, if you'd like to present argument in support of that motion at this time, you may.
Yes. The motion to declare Idaho's capital punishment scheme unconstitutional is based upon the Idaho Law Review article prepared just last year by Professor Cover at the University of Idaho. the article entitled Narrowing Death Eligibility in Idaho, an Empirical and Constitutional Analysis. As far as I know, this court is the first court to consider this article in a death penalty case in Idaho. So Professor Cover in her study attacked Idaho's constitutional or capital punishment scheme as unconstitutional as a whole. And so I'm asking for both, that the court consider declaring Idaho's capital punishment scheme unconstitutional on its face, and as it applies to Lori Vallow Daybell individually. And so, as Professor Cover indicates in her study, she studied a number of cases throughout Idaho, and so she concludes that the statute, Idaho, does not sufficiently narrow the number of cases eligible for the death penalty, that technically it's really just a matter of prosecutorial discretion as to whether or not the death penalty is sought. And the death penalty should not be up to a local prosecutor. It should be narrowed by the Idaho legislature, not just left up to a local prosecutor. And so we find that this narrowing requirement, as required by the Constitution, does not apply to this case. What have they filed against Lori Vallow Daybell? They've included allegations that she killed for money, that she killed in an especially heinous, atrocious, or cruel manner, manifesting exceptional depravity, that she killed in circumstances which exhibited utter disregard for human life, or that she killed which exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. So the local prosecutor is asking a jury in Ada County that if they find one or more of these aggravating factors, that she's eligible for the death penalty. That broad list of aggravators is not narrowed. And the constitutional requirement that we narrow down death cases to the worst of the worst. And in this case, there's no narrowing at all. And so because the local prosecutor is given the discretion, it does not satisfy the constitutional requirement. And in her study, she goes through all the Idaho cases where the death penalty could be filed, the death penalty was filed, or the death penalty was not filed. And my experience, I point out in my motion, is similar to Professor Cover's study. That is, of the 26 defendants that I've represented that could be charged with the death penalty, 9 of them were charged. Of the 9 that were charged with the death penalty, 1 received it. And that one who received the death penalty was Timothy Dunlap, of whom I was assigned to represent years after his crime. And so how does it happen that I am assigned to represent someone 14 years later after he's already been on death row 14 years? Because of the appeal process. Because if Idaho is successful in getting a jury to kill Lori Daybell, will she really be killed? History says no. So we're pursuing a punishment that will not happen. And how do I know that? Because of who's on death row right now in Idaho. I'll go alphabetically. Abdullah, he's been on death row 20 years. Thomas Creech, he's been on death row 40 years. Timothy Dunlap, he's been on death row 30 years. James Hairston, 25 years. Eric Hall, 20 years. Gerald Pizzuto, 35 years. 35 years on death row. And finally a judge said, okay, let's kill him. And Idaho Department of Corrections, we all know, just this past fall said, oh gosh, we don't have any bad drugs to kill him. So sorry, Judge, we can't kill Mr. Pizzuto. So he's still on death row in Idaho. Jonathan Renfro, he received his death sentence 5 years ago. Robin Rowe, the 8th and final person on Idaho's death row, she's been there 30 years. And a federal judge just within the last couple of years ordered a new hearing for her. 30 years after her crime, she's been ordered to receive a new hearing. So that issue's still on appeal. So why does Idaho seek to kill someone when they have no intention of carrying it out? So our process is flawed. Our process is replete with mistakes. The appeals process will go on forever if the state receives its wish of the death penalty in this case. And that's why I'm asking the court to stop this nonsense now and declare Idaho's capital punishment scheme unconstitutional.
All right. Thank you, Mr. Archibald, for the argument. What's the state's response on this?
Thank you, Your Honor. The Supreme Court first I would just incorporate Ms. Blake's comments, if possible, on the rightness. We don't think this is ripe. I'm not going to repeat everything she said. In terms of the substance of this motion, as has been stated at some point, the Supreme Court of the United States determined that the methodology used by the states to seek and determine the death penalty was unconstitutional. But it has come back as states have complied with their requirements. We call it usually the narrowing requirement. This is what the Law Review article is about. And there's two different ways the Supreme Court has said you can do that. One is to narrow the class of crimes, essentially murders that are eligible, or you can have a broad class of murders that are eligible and narrow those by aggravating circumstances, which is what the state of Idaho has done. And so the state of Idaho is in compliance with the United States Supreme Court's requirements. I did read the Law Review article. At some point, the test of whether or not our capital punishment scheme is narrowly tailored sufficiently comes down to the math. And her article establishes absolutely that it's very rare that prosecutors even seek the death penalty. And as Mr. Archibald has stated, it is rare that it's given. However, that's really not the substance of the argument. I would note even Mr. Archibald's own experience of 26 defendants who could have been asked for, only 9 were sought. I don't have the same experience as Mr. Archibald, but in the experience we've had in Madison County, in the majority of the murder cases we've had in the last 5 years, we've only asked for it in 1, and that's in this case, in conjunction with Fremont County. I would just note very quickly where the brief is based basically on this article. One, this article is not precedent. This article was brought about because the Supreme Court in Hidalgo, in denying certiorari, said, well, it'd be interesting, essentially, and I'm paraphrasing, it'd be interesting if someone did a study on this. But there's no Supreme Court case that says that what Idaho is doing is unconstitutional. There's no precedent whatsoever to support that. And that's And that's why relied on a law review article is not precedent. It is not law. I'm not going to shadow box with a law professor who's not here, but I would note there are a few issues I see with the article. One is she never actually presents any evidence to support her conclusion. In her methodology, I believe her methodology is flawed. She gets case files from the public defender appellate office and the people who defended these defendants. She never speaks with the prosecutors who made the decision. She never, she leaves out the narrowing function of the mitigation portion of our death penalty scheme and how that affects the prosecutorial decision and how that affects juries. And so, in short, it's not precedent. The state is in line with constitutional law, and for such, we would ask the court to deny the motion.
All right, thank you, Mr. Wood. Any rebuttal argument, Mr. Archibald?
No, Your Honor.
Okay, again, on this motion, it's a technical motion. I think it's most appropriate for the court to issue a written decision, consider the matter submitted, and it will be taken under advisement for a written order. The next motion we'll hear this is the motion to declare the defendant not eligible, and this motion was filed on January 4th. The courts reviewed the motion. A response was filed to the motion by the state. That was filed on January 12th as well. Mr. Archibald, if you'd like to present argument on that motion, you may.
Or I'll be presenting argument if that's okay with the court.
Thank you, Mr. Thomas. Yes.
Thank you. May I remain seated? I know everybody's asked, and I just feel kind of stupid if I don't. We brought this motion to the court's attention for a couple of reasons. I know the state's going to argue ripeness. They did in their response, but we want to bring it to the state's attention that they have an affirmative duty not to pursue the death penalty on cases that are not death eligible. That they have a duty to follow the supreme law of the land, and the law of the land at this point is the United States Supreme Court. And they have a duty not to subject Ms. Vallow to cruel and unusual punishment, which we believe also includes pretrial stress of knowing that the death penalty is on the table. Another reason we'd like to bring it to the court's attention prior to trial is that we don't want it to be a surprise to the court or to opposing counsel or anybody to be taken off guard when we present this motion again at the close of the evidence at trial, should the court not rule in our favor today. We want it to be that the court has taken a look at these cases, had plenty of time. We don't want to, we certainly don't anticipate a punishment phase in this trial, but we have to prepare for it. That's part of what we do. And part of preparing for that is we know that this motion is going to have to be brought, and we don't want to spring it on the court on a Thursday or Friday afternoon when the court has already sequestered the jury for a penalty penalty phase sequestration trial that will probably start on a Monday or just a few days after. So we wanted to bring it to the court's attention as well as to the state's attention. And finally, we wanted to bring it to save some time and some money in not having the state pursue something that will ultimately be found to be unconstitutional, and that being the death penalty in this particular case. So we believe that Edmond and Tyson are not only applicable to felony murder, as the state has indicated that these are both felony murder cases, but we believe that these are threshold death cases. To be eligible, in order to find someone eligible for the death penalty, they have to meet these thresholds. And so that's why we think that this case fits squarely within Edmond and the Tyson rule. And the Edmond and Tyson rule, which is, I know the state thinks that I'm making this up, but I didn't make it up. It's in the case law, that you either, in order to be death eligible, you have to kill or attempt to kill, or you have to have reckless disregard for human life, and you have to be a major contributor to the crime. Edmund said that, and Tyson clarified that. And so we don't believe that they are going to be able to prove that Lori was a major contributor to the crime, and we don't believe they're going to be able to prove that Lori actually participated in any of these events, or that she even knew about any of these events that were going to happen. She didn't anticipate them happening, and certainly was not a participant. If the court is looking towards finding that this doesn't fit within the scheme because it is a felony murder rule type of situation, the felony murder rule jury instruction in Idaho is 704C, and they have the standards on or about this day in the state of Idaho. A murder was in perpetration of some enumerated felony. But then their fourth criteria that they require under 704C is that the defendant or another person acting in concert with the defendant in furtherance of a common plan or scheme to commit that whatever enumerated felony is, killed the decedent, which would be Tylee, JJ, and Tammy. And so that, in a nutshell, is pretty much what the state is arguing in its conspiracy and in its murder charges that they've charged. In the grand jury proceeding, I'm not going to go into what any witness statements or anything like that, but in the instruction that was given on the first day, they talked about the conspiracy charge, and they talked about how aiding and abetting language was used in that, also in that conspiracy charge. And on page 15, on that first day, the prosecutor, I don't remember which one it was, but they said, I'm quoting here, it says, "For the crime or charge of murder in the first degree, you will need to find probable cause that on or about a certain date in the state of Idaho that the person that will be named aided and abetted another person or engaged in conduct which caused the death of the decedents." So we already know that they're going for the accomplice liability type of situation here with them being an aider or an abetter or a principal to the crime. So we know kind of that that's where they're going to go. So I believe that fits squarely within the felony murder rule because the language is substantially similar between aiding and abetting in a crime and the felony murder rule, which requires that a person either do the killing themselves or aid and abet in someone else doing the crime. As I said, when the state argues that these motions are not ripe, we think that it is ripe. The state has said that they are going to pursue this accomplice liability in the form of aiding and abetting, and based on that language, we don't believe, based on the discovery that we've reviewed and the ongoing information that we have, that there is proof that Ms. Vallow is death eligible. We just don't believe it. When the state indicates that the Idaho law allows the death penalty for charges of the defendant, their paragraph 2 or subsection 2, they indicate that the death penalty scheme in Idaho is what it is, and she meets the criteria there, and so therefore she is death eligible. Well, I would take the court to Article 4, paragraph 2 of the United States Constitution, which is otherwise known as the Supremacy Clause. And the Supremacy Clause says that the United States Constitution and any amendments and any law from the United States Supreme Court trumps the state law. And so that's why we feel that the arguments that we made with Inman and Tyson would be appropriate here. The state, in their third objection or third subsection of their objection, indicates that the felony murder cases that were cited by the defendant were inapplicable. Basically, that Inman and Tyson were were mainly felony murder rule type cases, and we have made those arguments that we believe that this is not only felony murder, but that it pertains to all Eighth Amendment death eligible clients. The state has indicated in their response that they will be able to prove beyond a reasonable doubt that Ms. Daybell intended for her victims to die. We look forward to hearing that. The state also indicated that Ms. Daybell participated in the killing of her own children. We look forward to seeing the evidence on that, because we don't believe that either of those statements can be supported by anything. That certainly is new information for the defense. But other than that, Your Honor, we believe that these motions are ripe. We believe that if the court were to wait until after a verdict in this case, we would have the jury sequestered for a week or more, just waiting to hear these motions and have rulings on these motions. And we certainly don't want the court to rush through, 4 motions today that we've had argued, all regarding the constitutionality of the death penalty. And so we ask the court to not rule that these motions are not ripe. We'd ask the court to rule substantively on the motions, so that if we do have to bring them up again at the end of the guilt phase, that we're not having the jury sequestered for lengthy periods of time, so that the court can rehash all of this stuff that we're arguing today. Thank you.
All right. Thank you, Mr. Thomas, for the argument. Who's responding for the state?
I am, Your Honor.
All right, Mr. Wood, if you'd like to respond, you may.
Thank you. I would again just incorporate the rightness argument we've made and proceed to the substantive portion of the motion. There is a very distinct difference between the cases cited, Edmund and Tyson, and the case before the court, and it boils down to the word intent. Felony murder is a very different crime than conspiracy to commit murder or premeditated murder. Edmund is a perfect example of that. You have an individual whose job was essentially to drive a getaway car, was separated from the murder, had no idea that it was going to happen, and was not the one who pulled the trigger. He waited enough from the murder that while he's liable for felony murder, he can't be executed. The real rule that comes out of Edmund is that punishment must be tailored to the defendant's personal responsibility and moral guilt. There's no pronged test that applies to every case that comes out of Edmund. That doesn't exist. Tyson stands even further for that proposition, that it's got to be tailored to the personal responsibility of the individual. And in Tyson, the individuals who were convicted of felony murder were close enough and acted with such utter disregard for human life that death penalty was appropriate. And yet, I'm sitting here discussing those cases. They really aren't applicable. Mrs. Daybell is not charged with felony murder. She's not charged with the death of her children and Tammy Daybell in furtherance of another felony. She's charged with conspiracy to commit murder. I'm not going to get into the evidence of the case. It suffices to say that a grand jury has found probable cause and that she did commit these crimes. And I certainly understand the defense is not going to come in here and admit that. But there has been a probable cause finding by a grand jury she committed these crimes. The state has complied with the rules laid out to seek the death penalty. Again, there's no case law, nor has any case law been presented that applies these rulings in these felony murder cases to conspiracies to commit murder. And if you look at, and even to separate it further, if you look at, like a criminal kingpin who's assigning people to go out and kill people, he's not the one pulling the trigger, but he had the intent. It's a conspiracy. This is more similar to that. This is not Again, this is not another felony being committed and people just happen to die in the commission of it. The word is intent. That's the issue here. And that's what probable cause has been found by a grand jury to exist, that she intended for her children and Tammy Daybell to die. The state intends to prove that. Absent any precedent that would apply this, the rationale of Edmund and Tyson to these cases, we'd ask this court to deny the motion.
All right, thank you, Mr. Wood. Any rebuttal argument, Mr. Thomas?
No, Your Honor, we're good.
All right, thank you. We'll consider that motion to be submitted as well under advisement. The court will consider those cited cases, Tyson and Edmund, and issue a written ruling. Next motion we will hear is the motion to prevent death qualification of the jury or for alternative relief. That was filed September 26th of this year, and the state filed a response last year. State responded December 1st. Counsel, when you're arguing this one, if you talk right into the microphones, the construction's getting loud. We want to make sure we get a good record on the audio recording as well. So, Mr. Archibald, are you going to be arguing this?
Yes.
Okay, Mr. Archibald, if you'd like to go ahead and perhaps yell into the microphone. If it gets too loud, we'll hear your argument on the motion.
Excuse me. Yes, this is a standard motion filed in death penalty cases because of how we pick juries. We have an objection to getting rid of people who say, yes, I'm opposed to the death penalty for personal reasons. That's an automatic disqualifier. And so what does that do? It causes juries in death penalty cases to be more conviction prone, more death qualified. So that's what this motion is about our process. I know we're working on a jury questionnaire right now. The court and counsel have submitted proposals, and we're all trying to figure out a way to get a fair and impartial jury. And the law provides that if anyone stands up or fills out the form, if any juror says, I am opposed to the death penalty for religious or personal reasons, they're automatically not on the jury. And so does that jury represent a fair cross-section of our community? No, it does not. And so under the practice of death qualification violates my client's due process rights to a fair trial by an impartial jury. That process that we go through, it violates the prohibition against cruel and unusual punishment because it produces juries that are conviction prone and death prone. And so they're automatically, and that's why I commented earlier that if we actually get to trial, so many of us death penalty lawyers say we've lost because we're going to have a conviction prone, death qualified jury. And so the process that there's some alternatives to striking all of these jurors who are opposed to the death penalty. There's some alternatives pointed out in this motion. One of the alternatives is let them stay. Let them stay on the jury. And half the states in the nation now have done away with the death penalty. And why? Because standards of decency change over time. Standards in our communities change over time. The amount of money it costs to give someone the death penalty and then not carry it out, it's not very fiscally conservative for a state to pursue the death penalty. So in a fiscally conservative state like Idaho, why Idaho still pursues the death penalty, I'm not sure, because it doesn't make any sense money-wise to pursue it when we don't carry it out. And so this process of death qualification it further insults the process where anyone who says, I'm a Catholic, the Pope says to respect all human life. The Pope says to be opposed to the death penalty. Anyone who says that is automatically kicked off of our jury. And so, again, that disrespects our constitutional notion of fairness of a jury that represents a fair cross-section of the community. And so for those reasons, we object to the way that the jury is selected and ask the court to select an alternative method.
All right, thank you, Mr. Archibald. Who's going to offer argument for the state?
I will, Your Honor.
All right, Ms. Smith, again, with the construction noise, if you don't mind, please speak loudly right into that microphone. Thank you.
Yes, Judge. Judge, I will be brief. This is a standard motion filed, and I applaud counsel's taking what is a standard motion and turning it into advocacy in Idaho, but he fails. This motion is really asking the court to almost be a super legislature and set aside the will of the people of Idaho. The law in Idaho is clear that jurors must be able to follow the law as written. They must be able to follow the instructions as given and not superimpose their own personal beliefs. That applies in any case, whether it's a death penalty case, a rape case, a drug case. And in this case, a juror who cannot follow the law and cannot rationally and realistically consider both forms of punishment cannot serve. That's not unique to death penalty cases. That is the standard for jury service. And so this motion asks you to ignore the fundamental premise, which is a juror must be able to follow the law. The state is asking you to deny this motion, to deny any of the suggested alternatives because none of them hold constitutional or legal muster and ask the court to put itself in the position of overruling the will of the people of Idaho. And as such, the state asks you to deny this motion.
All right, thank you, Ms. Smith. Mr. Archibald, any further argument on the motion?
Thank you.
Okay. Council, again, will consider that motion fully submitted and under advisement for a written determination. At this time, then, that will conclude the hearings in this case for today. Anything else we need to bring up, Mr. Archibald, this morning?
No, Your Honor.
All right, anything else from the state?
No, Your Honor. Thank you.
All right.